Well, aloha students, Mr. Fisher here. I'm going to walk you through strict liability. Hope you're doing all right. Keep washing those hands. Stay safe. Just a reminder, um, the reason we're going to stick with the distance learning is just to keep the continuum of education, certainly not to stress you out or overwork you. Um, yeah, we're going to dive a little deeper next week. We'll take a look at medical malpractice and product liability. The most important thing is you're taking care of yourself and your friends and your family. And just a reminder, I'm just here hanging out at home in Island Heights, so if you need me, just email me with any questions. My email is on Google Classroom. Cool. Quick review, tort. We've got intentional tort, and the evidence is what we can prove intentional tort with by doing or not doing something. Negligence is much more common, and the intention, there's no intent at all, and just try to file those away. There's a duty of care breach. Causation has two parts, cause in fact and proximate cause, and you have to have real damages. And the defenses to negligence are contributory, comparative, and there's an assumption of risk when you're doing something dangerous. Now, in New Jersey, just a heads up, we always use comparative. If the plaintiff can prove the defendant is at least 50% at fault, they win the case. Okay, so nothing's going to illustrate strict liability better than these controlled demolitions, so I'm going to go ahead and let this play for a minute. Doesn't matter how careful they are when they demolish something like this, they have to be careful. If anyone is injured, it's their fault, and because this activity is ultra hazardous. So these are all just some different sports stadiums being destroyed. There's just nothing safe about demolition. Okay, here's an inside look. Imagine the liability when you're doing something like this. Okay, I could watch that all day, but let me keep going for you here. Alright, so strict liability because of the ultra hazardous nature of the work. And there is no fault, it's simply because the activity is so dangerous. Things like having dangerous pets and things like guns are ultra hazardous. Another thing to think about is toxic torts. Unfortunately, all throughout history, companies will dispose of toxic chemicals simply by dumping them or burying them or burning them. That creates a lot of health issues, and we refer to those types of torts as toxic torts. This is very recently, PG&E, who we will look at quite a bit, they're responsible for what's called the campfire in California, and you can see the statistics here. Serious damages. If you look at the picture on the right, the PG&E, they had a fault in their electrical grid. They were providing electricity to these families in these different towns out in the wilderness, and they knew that this thing up here I'm touching with my mouse would spark periodically, and they didn't try to fix it, and that became the cause of this tort. Ultra hazardous. Okay, PG&E is also at the center of the movie Aaron Brockovich. Hopefully we'll get back together, we can watch it in class. They were dumping toxic chemicals. It ended up leaching into the groundwater, and then people were drinking the water not knowing how poisonous it was, and it created a huge cluster of cancer. Great movie, if you can find it, definitely go watch it. Check it out. And in the movie and in real life, it had to do with them dumping millions of gallons of wastewater and around the town of Hinckley, California. This ended up being a class action. That's where all of the injured plaintiffs get together, and you can see it was the largest settlement, $333 million. This is the real Erin Brockovich, not an attorney. She's actually an investigator for a real estate company that was just involved with the buying of property around the town. Things seemed to get suspicious, and she actually is the reason that this was all discovered. Really cool. The corporation is always, unfortunately, getting in trouble. Pretty terrible. You can learn about this, and we'll look more at toxic tort another time. And just a heads up, associate's degree. You could get that at OCC. Okay, so again, ultra hazardous, things like demolition, wild animals, even your pets and your backyard pools fall under strict liability. And just a reminder, New Jersey, we have this contributory negligence. As long as you can prove 50% at fault, you can recover damages. If it turns out the plaintiff was more than 50% at fault, then they cannot collect damages. Here's an example of a toxic tort. Mother found that her son and a dozen other children in the neighborhood had leukemia. She sued the chemical company that contaminated the local drinking water. The company had been dumping toxic waste into a nearby stream. Now, pets, you have to be careful. It's not just wild animals, like if you had a terrarium with some kind of rattlesnakes or something, but also pets like dogs. Okay, and then defective products. Believe it or not, we have about 38 million people each year that need medical treatment due to a defective product. For me, that hits home with airbags and things like that, with cars, seatbelts. And if enough people are injured, the plaintiffs will typically form a class action suit. Here's another one. This is a little bit old, but fen-phen. They sold it on TV to people as a miracle drug to help them lose weight. And unfortunately, the ingredients cause heart attacks. And you can see the numbers here. And there's still some of the people who were injured or killed, or the families of those people, have not chosen to settle. And they're still seeking their day in court. Another problem with this is a company that made fen-phen, there's no way they have that much money. So even if you win the suit, the chances of actually getting all that money are slim to none. So you should be able to answer this question for yourself. Why is it a good thing that people can sue a company over damages caused by defective or dangerous products? Maybe you don't think they should, or you should maybe be thinking about damages should be limited. And the biggest thing is to send that message back to these companies to make sure that their products are safe. So what do you think? Is this strict liability? Bob has rabies and needs a vaccine to save his life. The vaccine is well tested, however, some people get sick from the vaccine. Bob is one of those people that gets sick from the vaccine. Can he sue under strict liability? Probably not, because the benefits outweighed the risk. Rabies, basically, if you get it, it's almost 100% of people would die from that. So he really, not getting it would have been very hazardous. Okay? And this guy, there's a lot of these tourist places where you can go and see somebody wrestle an alligator or, play with these venomous snakes. Ultra hazardous. There is some groundwater. You can see how filthy it is there. Alright, unfortunately we won't be doing these workshops. And let's talk about dogs for a minute. That's my little friend Shay on the left. And typically, we all love our pets, but we have to be careful because just by having a pet, you have to be very, very careful. Otherwise, you could open yourself up to liability. And just a little bit of info here. This has to do with the number of bites reported by dog breed. And just for yourself, be careful when you approach a dog. You always want to be calm and gentle. Keep your palms up. You want to get low, and then the dog will naturally come to you at that point if it wants to be pet. Don't do it the way they are doing it in the picture where you come up on the dog from above. That really is scary for a little dog, so you need to keep yourself safe as well. You have a duty of care, and never approach a stray dog. Okay, so when it comes to the defenses for strict liability, it's going to be the plaintiff should sue for negligence, no causation or damages, consumer misuse of product. That is their only way to defend this. So you can see the first one, they're still basically trying to put the blame on the user. And of course, you can't sue if you don't have damages, so that can hopefully be a good defense for one of these companies. And of course, if you buy hairspray and then you use it to do something you're not supposed to do with it, that would be one way that they could get out of their strict liability. Something like hairspray or some other product that's flammable, comes in a can. Obviously, if you are doing something dumb and get injured, that's really more on you, especially in the state of New Jersey. Okay. And just a reminder, like with cars and dogs, you do have a duty of care when you're driving or you approach a dog. So you have to be careful with that. Pets bite people, so we have to be very cautious. Okay. So what do you think? Khalid gives his friend a bite-sized Snickers. Apologies for the typo. When she bites into the candy, it's rock solid and she breaks her teeth. There are extensive dental bills from the injury. So is this going to be a tort? Probably not. Basically, there's nothing ultra hazardous about eating a Snickers, and it was a gift. There's no intent, and there's really no negligence either. This is probably not a tort, and it's just basically if there was a lawsuit, it would get thrown out as a frivolous lawsuit. Okay, just so you know, you can't wait. If you're ever injured, you need to file those suits. The statute of limitations is like, how long do you have to sue? 2 to 3 years typically. And frivolous just means that the lawsuit has no merit. If it's dismissed by the judge, the plaintiff may have to pay the defendant's legal bills. So it basically becomes a countersuit. You always want to make sure you have a really strong case before you go to court. And again, hopefully by allowing us to sue companies over products and things like that, it helps keep the businesses more honest. So is this going to be strict liability? Ray Ray finds evidence that the tap water in her high school is high in lead and it's causing learning disabilities among the students. So if does Ray Ray have a case, and who is liable? Cool. I just want to show you this. This is actually a real picture from Tom's River. This is the site of an old ink factory where they made all kinds of dyes and inks. And what's happening in this picture is that the company throughout like the 60s, 70s, and 80s would have toxic chemicals. Instead of like sending them out to a treatment plant, they would just put it in barrels and then bury it. And behind all the yellow barrels is a river. That's actually the Tom's River. It feeds into the Tom's River. So over time, these barrels would decay and leak, and the chemicals leached into the groundwater, created lots of cancer in Tom's River. It took tons of lawsuits and action by the people in Tom's River all the way out to Ortley Beach to get them to clean it up. This is now a Superfund site, and what's going on is they take the old barrels, they put them into a new barrel, and instead of burying them, they're storing them in warehouses. Still not a great solution, still tons of toxic chemicals, but definitely much better than just burying them in the ground. And that's Sipagagi. You can Google it. It's an amazing story, and it took a lot of work from locals to get this cleaned up. They're still doing it now. That picture could have been taken yesterday. And that's a Superfund site. The Environmental Protection Agency is out there trying to keep us safe, but unfortunately it has to do more with cleanup. They're not necessarily stopping and preventing contamination, but rather they are out there trying to clean it up after the fact. Okay, you're actually going to this week look at the case of a dangerous dog, and I'll be posting that on Classroom. And just so you know, a lot of people, a lot of businesses pour their money into reforming tort because they don't want to be sued. There's a bunch of reasons. The thing you need to file away is that New Jersey, especially for medical malpractice, think about little Tran that we saw in the negligence. They're going to cap the damages between $250,000 against a doctor up to $1 million against a hospital. That's to prevent frivolous lawsuits. And also, the worst thing for society would be to sue a hospital and have them close their doors. That would hurt everyone. Okay. So, for week 2, we're going to look at 2 cases. You're really only going to have to read them both and then report on one. The first one is a dog bite in Utah. Kid was playing under a fence. The dog on the other side didn't just bite him, it actually bit his hand off. Amazing, sad, scary stuff. And then the other case was, I don't know if you've noticed, but a lot of people like to travel with their pets now, and so they'll get what's called an emotional service dog sort of thing. You pay someone online and print it out. It's kind of a sneaky way to get your dog on an airplane. But those emotional service dogs, they can get stressed out, and they do bite people. So just be careful. Don't approach dogs. Strange dogs are dogs you don't want to approach. And of course, our friend Shay over here would never hurt a person, but I'll tell you what, if she sees a squirrel, she goes right after him. Okay, I'm going to do a quick pop quiz. You don't have to record anything, but feel free to shout out at your computer. And again, there's Mike Tyson with his pet tiger, very ultra hazardous. Can you list the 3 types of tort? I gave you a hint there. The first one is starting with the letter I, then N, then S. Next question. What are the 4 elements of negligence? And that's a little bit of a helper there. First one starts with D, then B, then C, then D. Okay. What does comparative negligence mean? Those numbers don't mean anything on the side. Okay, so let's see how you did. List the 3 types of tort: intentional, negligent, strict. And elements of negligence. Negligence is always the most common type of tort, so it's important that you know there's a duty of care on both sides, there's a breach, and then you have to prove that the breach of duty was the cause in fact and the proximate cause, and then there's actual damages in the form of money, economic hardships. Think of Miss O'Leary and the cow. She did have a duty of care. She did breach it when she set that lantern down too close to the cow. The cow kicking over the lantern did cause the fire, in fact, but to say it was the proximate cause of burning down an entire city, it's just not something that you could say is foreseeable, or that anyone would be able to predict that would happen, to burn an entire city down. And yes, there were damages, but she would not be held liable because she did not have proximate cause. I hope you're doing well out there. You can always email me. Take care, and hopefully we'll be back in class soon. Have a great day, everybody.